Firstly, if he is facing an inquiry, he has no right to have his resignation accepted. His innocence or guilt will be determined by that inquiry. And second, even under normal circumstances, if he is not facing an inquiry, his resignation does not become effective the moment he gives it. His resignation becomes effective the moment it is accepted. In the case of a judge, the situation is otherwise. A judge, being a holder of a constitutional office, as Dr. Abhishek Singhvi rightly mentioned, based on that 1977 case, the judge's resignation becomes effective the moment he delivers his resignation. So if he signs and sends it to the president, the resignation is accepted. He has voluntarily relinquished office. Now the judge therefore has a right to decide the timing of his own resignation. If there is an inquiry pending against him, that can't deter the factum of his resignation being accepted or not being accepted. Acceptance of his resignation is a mere ministerial task. And therefore it only notes in the government file that and a notification comes out that a resignation has been accepted. This being the situation, the way our constitution is structured, ordinarily we operate on the principle of separation of powers. The legislature is separate in its exercise of power, the judiciary is separate. But impeachment is one process where there is some interaction of the two powers. If a judge is prima facie guilty and a motion for an inquiry against him is presented, such a motion is really under legislative control. A judge functions independently of the legislature, but the legislature decides whether this judge is guilty or innocent. Now, the manner in which our constitution and our law is structured, that a motion needs to be admitted by the speaker or the chairperson. It has to be signed by a certain requisite numbers of members of parliament. And the chair admitting that motion constitutes an inquiry committee which comprises of a sitting judge of the Supreme Court, a Chief Justice of a High Court, and the third member will be a jurist of eminence. Now, past experience has shown, you have the 1949 case of a judge of the Allahabad High Court, the first case of impeachment which came in. Even when the federal court was in existence and before the Supreme Court was formed, when an impeachment motion came, the judge in question resigned. You have a recent case of the Madras High Court judge where the motion was admitted, the matter was pending before the committee, and while the committee was proceeding with evidence, the judge in question resigned. You have a third case in the mid-90s where a judge of the Supreme Court, even though the motion was not accepted because of the committee had found him guilty, but the motion was not accepted for want of quorum, and the Supreme Court was faced with a very difficult situation whether to allow the judge to function or not allowed to judge the function. And the Chief Justice used for some time at least his administrative powers and did not assign him judicial work. So after some time the judge in question resigned. And then you have the recent case of Justice Soumitra Sen, where this House, after an extensive debate, passed the motion, and before the motion was taken up for consideration before the House of People, the Lok Sabha, the judge in question resigned. Now this power is exercised very carefully. So you've had about 4 motions so far in the last 65 years. And in all 4 cases, a virtual stalemate has been created. One lost out because of want of quorum. One could not fructify because the judge in question resigned during the pendency of inquiry. And 2 were frustrated because the judge in question resigned during the pendency of the impeachment process. So the problem is real. The judge in question himself chooses to decide whether he should allow the proceeding against himself to continue or not. Now recently in the inquiry against the Madras judge, when he sought to resign, I am given to understand that at some stage it was under consideration whether, notwithstanding the fact that he has resigned, could the impeachment process continue. And the view expressed was that impeachment lies against a sitting judge. The moment he resigns, he ceases to be a judge. So the procedure can't impeach a person who is no longer a judge. And since he is no longer a judge, the process fell down and it collapsed. And therefore the judge in question, so in each of the cases, the proceedings really had to be closed. The object of the impeachment is much larger in public interest. It's not merely to hold a particular person innocent or guilty. Of course, his own reputation is at stake. But the dignity of the office of a judge is much higher than the person. And therefore, if he is innocent, he requires to be vindicated that a false allegation made in the impeachment motion should not act as a stigma on him. So it is in his own interest that the proceeding is concluded and his honor is vindicated. If he is guilty, then again the office is much higher than the person. And the office's dignity has to be saved by getting rid of the man because he does not deserve to serve on that office. We are today confronted with a limited question. Once a procedure has started, the motion has been admitted, can the person against whom an accusing finger has been pointed out and a prima facie merit has been seen in as much as the chair has admitted the motion, can he frustrate the inquiry by resignation? I am one with the mover of the motion, Mr. Dua, and those who have spoken in favor of his amendment. And my reasons are, one which I have already stated, that it affects the reputation of the judge. Judges can't go to the media, they can't appear before television, they can't address press conferences and proclaim themselves innocent. His only chance of getting a finding of innocence is in that inquiry. And therefore, for his own reputation and in the interest of his own reputation, it is necessary that he allows the proceedings to continue. Secondly, if the judge in question is guilty of misconduct or allegedly guilty of misconduct, besides himself, it impacts two other factors. It may throw some light on the cases which he has decided in relation to which the allegation of misconduct is made. Therefore, in order to determine what impact it impinges on those cases and on those judgments that he has delivered, which may be a subject matter of this misconduct, this procedure needs to be concluded as to a determination made whether he is guilty or otherwise, so that the impact it has on the administration of justice in relation to those cases is also known. Thirdly, sir, and this is a very serious point, we live in an open society today. Transparency is the essence of any democratic functioning. It is the best disinfectant against all allegations of misdemeanors. And therefore, every institution in a democracy, and this is also the insistence of the judicial institution, that all institutions must be subjected to a certain amount of transparency. When the Right to Information Act has been made applicable, some people feel that it is creating problems. Others feel that yes, it is creating problems, but the benefits of this are also far too many, and we must allow this to continue. Amongst all the pillars of the state and our constitutional system, the non-transparent institutional functioning is that of the judicial institution. How appointments are made, it's a non-transparent procedure. How functioning takes place is a non-transparent procedure. The in-house inquiry mechanisms are a non-transparent functioning procedure. And therefore, if a judge facing an inquiry can frustrate that inquiry by submitting his resignation, then we are adding to that procedure by which you sweep the dust below the carpet. and then say now that he has resigned, we need not know what his actions of misconduct were. And that non-transparency in the judicial process continues to subsist. And it is this purpose which further would be served if this discretion of a judge facing an inquiry, which is absolute, that he can choose the timing of his resignation, is taken away from him. And as in the case of a civil service, if you are facing an inquiry and a motion has been admitted, your resignation can't be a voluntary act by which you resign and that's the end of the matter. Your resignation will require an application of mind by the accepting authority, and the accepting authority will decide whether it is in public interest to allow the inquiry to continue, or the accepting authority feels that this is a case where the ends of fair play and justice would be subserved by allowing his resignation to be accepted and close the matter itself. It is therefore, sir, I think this matter does need extensive consideration, and I would urge the Law Minister that, since we all know that private member resolutions are really a food for thought, they don't get converted into legislation. But since Mr. Dua has thrown up a very important point for our consideration, the Law Minister should seriously give it a serious thought, and hopefully at some stage this may be incorporated in any official response that the government does make. Thank you, sir.
Thank you.